So, good morning, everyone. Welcome to the weekly Saturday knowledge sharing webinar organized by Meta and Meta. Today's topic is an insight into winding up by tribunal under section 270 to 302 of the Companies Act 2013. Friends, this little offbeat subject, and it is not too widely known or impractical for closure of the company. Two cases in NCLT we have it's been filed and it's also resolved also. We have handled one that kind of case, and also Mr. Dakshit, also our today's panelist has handled. So we thought that we should take this topic under Companies Act, friends. It is not under IBC, Insolvency Bankruptcy Code. What we had a myth that everything except that striking off is shifted to IBC, Insolvency Bankruptcy Code. But these are the provisions under which the company get closed under section 270-302 of the Companies Act and the Companies Act. So of course, here the judiciary is NCLT. Under Companies Act, now every judiciary is NCLT. So that way it is under the purview of Honorable NCLT, but the provisions are of the Companies Act 2013. And it's a unique thing, and that's why we thought that we should take up this topic. I know under this, people may be thinking that it is for insolvency professional and all that, but this is something relevant for the company secretary to be knowing, and a chartered accountant and advocates and the professionals who are handling the compliance and legal matters. So with this, I'll just introduce today's panelist, Mr. Dikshit Mehra. Welcome, Mr. Dikshit.
Thank you. Thank you, Mr. Mehta.
To formally introduce Mr. Dikshit Mehra, he is LLB from KC Law and has been with Rajani Associates since then. At present, he is an associate partner of Rajani Associates, and he specialized in commercial litigation, intellectual property rights, IBC, and white-collar crime. He regularly provides counsel on the matters before investigating agencies like CBI, EOW, SAFIO, ED, etc. Additionally, he is frequently represent the client before the authorities. He has handled cases across numerous industries, including banking, finance, telecom, pharma, chemical, media, entertainment, hospitality, power, steel, infrastructure, and oil and gas. He also advises insolvency resolution professional on crucial matters, and one of them is myself also, and litigation that arises during the CRP process along with the general process of advisory. The award recognition, Rising Star in Legal Field by Governor of Maharashtra, Top 100 Lex Falcon Awardee, Global Excellence Award 2024. Welcome, Mr. Dakshit. Thanks a lot for your time. And friends, he has certain difficulty today to switch on the video. So he will be available, but he will be without video and answering the questions. We have today's presenter, Ms. Shivani Patil. She is a legal consultant over 4 years of experience in corporate law and IBC and IPR. She regularly works on the cases before NCLT, handle legal filing compliances, and works on trademark, copyright, and she has completed her law from Government Law College, Mumbai. Thanks, Shivani.
Thank you, ma'am.
And I need not introduce Mr. Bala, who is there with us. With this, I'll request Mr. Dakshit to say a few words on the topic of this particular, and then Mr. Bala for 1 minute, and then we can start the presentation. Over to Mr. Dakshit.
Good morning. Firstly, thank you, Mrs. Mehta and Mehta team for having me here. Sorry, for those reasons, my video will be off. And good morning to all the participants. So to begin with this topic, as Mrs. Mehta sounded off that, it makes a lot of people are aware of these provisions, which is under the winding up. So just to take a little background, which I'm sure most of the people will cover, but just in a short nutshell. In the erstwhile 1956, we had the provision 433 ENF, where the company was unable to pay its debts. Now, if the company was unable to pay its debts, that was the company, and the petition could have been filed by any creditor or the contributor before the respective High Court where the registered office was located. Thereafter, with the advent of IBC in 2016, the Companies Act was obviously then modified to the extent to say that the provisions of 9, 7, 9, and 10, the inability to pay debts then came out from the provisions of 271, which is parameter to the 433 under the 1956 Act. And then you had these provisions of 7, 9, and 10 under IBC. Also, an important factor here is that there was also a mechanism where the voluntary liquidation, which now has a codified chapter under the IBC, which is the section 59 onwards. So earlier, there was also a provision of voluntary under the Companies Act. Now, your provisions have been there shifted to your IBC. Now, having said that, what are the provisions and why do we come before the company court? Now, there are certain circumstances as we go by when Shivani will take you through the slides. You'll see there are different circumstances, if I may put it, then where the company petition for winding up can be done. Who are the people who can file for winding up, whether the company itself, the persons, the contributors, even any person authorized by the central government in cases of fraud. Then what are the powers of the tribunal, the directions, the statement of affairs, the entire very important factor which I may point out, because throughout the sections, I think everybody will realize that where is this, because everywhere the nomenclature is of liquidator, official liquidator, and everything. Let me be clear on that it is the powers are coming from the sections, I think it is close to 275, where they have specifically mentioned about the point that the liquidator will be appointed by the tribunal amongst the IPs registered under IBC. So there's a very specific clause which is mentioned within that section of 275, which clearly says that so nothing to do with our High Court. We no longer are related back to the High Court where we used to have the official liquidator, the provisional liquidator. It's a liquidator who is appointed in accordance with the Act, but relaying it back to the insolvency professionals. Then obviously you have the process which involves everything from right up to preparing your books. Once the company gets, then there's a registrar. You have to send your practicality. You have to send your petition once it gets admitted. It will go back to the ROC if they have any objections to your income tax authorities. All this then comes, and then there is a final order of winding up passed by the NCLT, and then the process, as we'll be seeing it in the slides, that begins.
Thank you, Dakshat.
Yeah.
With this brief, you have given a very good idea about what it is and the difference. And as friends, our presentation will go, the clarity will be more on the topic. Yeah, over to you, Mr. Bala.
Good morning to all of you. As our panelist Dipti also said, actually, now more or less everything is coming into IBC, but yet there is a Companies Act where there are various methods of getting the winding up, either voluntarily or compulsorily, which also can be done by this section. That is where Shivani is actually going to take through. But the only thing is what happens is when we are talking about it, the winding up, we face a lot of challenges. As you know, in our country, the legal procedure is a very, very complex system. Number one, it takes enormous time and there are delays, there are conflicts, various things are all taking place. That is one thing. Because basically what happens is when the company strike, there are different stakeholders are there. So disputes among the stakeholders like creditor, shareholders, director, minority, majority, all those things are out there. So the question is the grounds are winding up. Of course, Shivani is going to discuss many things. And out of that, one of the things which actually comes to my mind is winding up on just and equitable basis. What is that just and equitable basis is really, really a questionable thing. Now where it can be called just and equitable. And again, the just and equitable is actually a discrimination given to the tribunal In their opinion, if they think it is just and equitable to wind up, they can order for the winding up. That is what it is happening. So circumstances may be happening in sort of a private company, closely held company, a deadlock between the two parties who are holding 50% share. Nobody is able to take a decision. Nobody is coming to end. Business is not going to get along. That could be a just and equitable things that can be done. And second thing is say operation done to the minority. That also can be done. So there are many grounds that there has been some decided case laws are also there by the NCLT. In fact, way back in 2005 and 2008, we came across one of the private investment company, I think Dale and Carrington Investment Private Limited versus Portable. So what happens is the bona fide intention of the board of directors, without informing the shareholders, allotting the share and ciphering the mud, etc., and other thing and all, which has actually happened. So in such case, NCLT felt in the discrimination just an equitable basis the company is to be wound up. Similarly, there was another case which was there in MSDC Radhakrishnan versus MSC Chandrasekhar Raja and another. That case also, this principle was actually applied. So there are selected cases are there. And another thing is there, what is the time frame of getting the winding up? Although we think it is the winding up, it is not the thing. Many times it has seen it has taken long enough also. So as Shivani takes up, she is going to discuss the challenges as well. Also, it is a very interesting topic. So we have an expert who handled this, and of course, Dipti has been actually handling various IBC cases. Even our presenter is also representing the NCLT and preparing the things and all. We love the expertise of their practical experiences on this related matter. As usual, I request all of you to put your queries on the chat box. We will be taking up then and there, and we will be discussing the things. Thanks a lot. Yeah. Yes, Dipti.
Where you started and Dikshat has started replying that also. Thanks, Dikshat. Yeah, Sivan, start. Yeah, please.
Hello everyone. So as already discussed by our panelists, today we'll be discussing winding up of the company by the tribunal and the Companies Act and the relevant rules. Let's start with what is winding up. A winding up is a process by which a company will cease all its operations, it will liquidate its assets and pay off all the debts, all the liabilities, and distribute the remaining funds among its shareholders and contributories. After all of this process ultimately leads to the dissolution of the company as a legal entity. Now, what are the objectives behind winding up? It could be asset liquidation, convert all the company's assets into cash, then debt settlement, use all the proceeds for payment of the creditors and all the other cost, liquidation cost. Then is distribution. Anything remaining after all the distribution, the residual funds will then be given back to the shareholders, if any. And dissolution, finally, order of the tribunal for dissolution of the company. Section 270 particularly talks about modes of winding up, which ways the company can be wound up. First is by tribunal, which is compulsory winding up. Then is voluntary. Now, particularly voluntary or voluntary has been omitted from Companies Act and then be shifted to IBC, Section 59. So this particularly part 1 of Chapter 20 particularly only deals with voluntary liquidation by the tribunal. Then winding up by tribunal. What are the circumstances under which the company can be wound up? First is unable to pay debts. In a situation where...
Shivani, sorry, just to I think there were a lot of queries on the 59 versus this and what is the more easier and fundamental. I think it all depends on what obviously the company wants and also the fact that what are we looking at and how it is easily done in terms of the process. Sorry, just wanted to mention that. You can go
ahead. When a company can be wound up, one is unable to pay debts. When the company is not in the position to, pay off the debts, it can go for winding up. But mostly now Section 7, 8, and 10 of IBC are preferred for, liquidation or dissolution or revival. Then is special resolution. When a petition is filed by the company itself, if a special resolution is passed by the company, they can go for winding up under this section. Then is acts against national interest. When a company acts against the sovereignty and integrity of India, the security of states and foreign relations, public order, morality, etc., it can be wound up under this section. Winding up under order under Chapter 19. Chapter 19 particularly deals with revival and rehabilitation of sick companies. So under, if anything under there, it can be wound up under Section 271. Fraud or misconduct. The tribunal, if it receives any application by the registrar and it's of the opinion that a company was formed with a fraudulent aim and unlawful purpose of its affairs, which have been conducted in a fraudulent manner, or persons who have formed a company are guilty of any fraud or misconduct, it can file a petition for winding up. Then is failure to file returns. If the company for the preceding 5 years has failed to file its returns with the registrar can file for winding up of the company. Now, just and equitable as per the tribunal. This could be, there could be many circumstances under which the tribunal might find it just and equitable to wind up a company. One of which is a deadlock. Now, when two or more people do not agree with each other on a certain situation or a certain agreement, it could be known as a deadlock. What happens here is that if there is a deadlock between management of the company, if there is a deadlock between major shareholders, and the company's progress is hampered or performance is hampered, work is hampered, then it could be one of the grounds for winding up of the company. Second is loss.
Yeah, Shivani. We are friends, we generally face that operation mismanagement, and when there is a deadlock and the situation, and it will affect the working, and if the debt of the company is mounting, and it will affect the other creditors and who other stakeholders, then the tribunal will take this call. Yeah.
One of the circumstance could be loss of substratum, in which the object for which the company was formed is fails, for example. Then it could lead to lead to loss again. Hence, a company can be wound up under this section. Then is operation of minority. Any another ground for winding up could be that where the principal shareholders adopt aggressive or oppressive policies towards the minority shareholders. This can be one of the reasons. Fraudulent purpose, of course, and company, if the company was formed, it was never really a company. It was formed only, to make some fraud or something. The company can be wound up under this section. Then is Section 272, which deals with who can file.
Shivani, I think one of the participants, Mr. Rajendra, has asked the same thing, that, recently some Chinese companies set up and CS have been prosecuted, but whether this company has been liquidated. See, this power is with the authority, that is government and government appointed authority. So, we are not knowing at present whether that company has filed or not, but it has to go through the process. The registry will file before the NCLT, and then the case will go ahead. Mr. Dixit, if you can say on that something, if you want to add.
Yeah, I'll add it in a bit. You can continue. I will add that. I'll address that.
Yeah, okay, fine. Yeah.
And another thing is that when we are talking about the just and equitable basis, I think long time back it was the case of UK, not in India. But the thing is, what has happened is the partnership firm, they actually converted the company in a private limited company, but the business was conducted as if, like a quasi partnership. So when these things were going on, the decision were taken, quasi partnership, etc. That was also treated one of the ground of the just and equitable basis. This is a very old case. But of course, Indian case, I really do not know. But she has already covered it. The loss of subtractive, etc., another thing and all, she already covered it. Yeah.
Okay. Yes, you are.
So who can file for petition for winding up? One is the company itself by passing of the special resolution. Then could be any contributory or contributories together or can file for it. The central or the state government can do it. Then, of course, if we see in cases falling under Section C of subsection 1 of 270, which particularly deals with somebody who has acted against the sovereignty and integrity of India, the security of the state. So these people can file for winding up of the company under this section. Also, who else? A shareholder can file for winding up if the shares which he holds for the last six have been he has been held by him for at least 6 of the last 18 months, or it has been inherited from a deceased holder. Who else? A registrar can file for a petition if it believes that a company is unable to pay its debts after obtaining approval from the central government. One of the most important document that is required would be the statement of affairs. One more thing, the steps for filing of this petition I have not covered in this presentation. However, I would just like to take you all a very quick glance to the steps that would be required. Uh, First would be, of course, the petition must be presented. There are certain in companies at winding up rules. If we see, there are certain forms that have been given. Every filing that has to be done with the tribunal comes in a certain format, which is called WIN forms, WIN. This petition comes in form WIN 1 and WIN 2, which has to be verified by an affidavit. If the company is made by, if the petition is made by the company, by its directors or any other authorized person. Compulsory document is the statement of affairs, which has to be filed with the tribunal. Then, what happens after this petition is filed? The tribunal will fix a date for hearing for the petitioners. If the petition is not made by the company, notice will be sent to the company and an opportunity to be heard will be given before advertisement directors to be given with respect to the petition. Then contributories will be served a copy of the petition by the person making the petition. Then notice of petition will be given in advertisement 14 days before the date fixed by the NCLT or the tribunal. Which
Not covered in the slide, Sugani, what process you are talking?
No, I have not covered it in the slide, but this is just a quick process as to the in practicality how we file it and what happens.
Sugani, in that earlier slide, I think on right hand side, 2 more applicant you missed before this. Just go ahead.
Sure.
Yeah.
It's the state government or the central government. So in this case, as I discussed before, it is the registrar. In case if there are no filings done, annual filings done, so that could be any other person authorized by the state government. And A and B is both company and the contributories.
Yeah, you can go ahead.
There is a question has come actually, whether under section 271D, can any other interested person, that means shareholder or any director, can file a winding up petition other than ROC?
No,
Yeah, Richard has answered that. Yeah.
Yeah, if the company has made a default in filing with the registrar, yes, it is only the persons, the registrar who goes and files, and even the director can actually go and say that yes, there is a default in filing the statements. So technically, if the company has for 5 consecutive years, we are very much aware that how the striking off issue happens. But in this case, the shareholder or the director can always go ahead and say that he is defaulted in filing for whatever reasons and can go ahead, because if you read 272, so one has to read 271D with 272, because that says is the people who are there who can file the petition.
But I understand actually any shareholder, etc., they can actually approach the ROC for any default, and he goes to the ROC, then ROC take a call. I do not know whether in this case he is asking whether he can directly file the.
If one has to read, I think to the best of my recollection, one has to read 272, I think, where there is a specific mention that where the registrar can or is rather entitled to file a petition. I think under 271. I think there is only an exception of, I think, A, if I'm not wrong, of 271. Rest in all other cases, the registrar also has a right to present the petition.
Yes, he has written that after obtaining government approval, he is unable to pay it.
Yes.
And somebody is asking statement of affairs should be on the audited statement or just certified by the directors?
Sorry?
Statement of the affairs.
Yes.
Should be the audited statements or it is just certified by the auditors? Directors.
So in usually the statement of affairs, if we go again by the Companies Act, when we used to present, under the Erstwhile Act also, So in practicality, sometimes the whatever statement of affairs are there, audited by this or if verified by the CA should suffice. But again, it really depends on any member to member or any NCLT who will insist on it. Practicality, only filing the statement of affairs with the under the aegis of the CA should suffice. But again, NCLT may ask you to give the audited ones also.
So that will depends upon the members.
Yeah,
Whatever
yes.
Yeah.
Sometimes they go ahead and they will actually even ask you, okay, fine, you have filed the statement of affairs, no problem. We just wanted that you have filed the statement of affairs. Sometimes they will go ahead and they will ask you, because then there is also directions when the winding up is there, and they have to see that the statement of affairs are filed, because then that is a prerequisite. I think it comes under 274.
Okay.
Because then the directors will not have the right to file their say on the petition.
Yes,
Yes, Shivani, go ahead.
So next, we'll be talking about the powers of the tribunal and appointment of the liquidator. Once the petition is filed, what are the next step? What happens? The tribunal may then first either dismiss the petition on the grounds, after hearing all the parties and coming to a conclusion that the petition is liable to be dismissed. It could then either pass an interim order. It could appoint it after interim order. It appoints a provisional liquidator. Then would be the winding up order, and then would be any other suitable order. If it thinks that the company could go through any other route and not through winding up, it could pass that order also. If no refusal can be done by the tribunal on the grounds that there are no assets in the company. Generally, after filing, the Act says that the decision is to be given by the tribunal within 90 days, whether the winding up order will be passed or no. And refusal is only possible if there is any other alternate remedy, as I discussed. Directions for filing of statement of affairs is covered under section 274. The procedure for
When you say Shivani,
yes.
Shivani, when you say any other remedy,
Yes.
I'm not very sure. I'm just thinking little widely. Any other remedy, either it could be a possibility of revival of the company also.
Revival, not particularly, because
Yeah.
under Companies Act, it's not very clear under this section, but also they have written revival, but there are no specific provisions that talk about it.
Actually, it is silent, so it will be left to the judiciary that what if any alternate remedy, either for the closure or for their continuation of the company, whatever it is. It is left.
Because if I read the Companies Act to the various sections, the alternative remedy could also possible for the revival of the company, but the thing is, the relevant things are totally silent. How it is, what is the methodology, all those things.
Yeah, but that's why even the judiciary may direct, suppose there is a dispute or suppose there is no asset or the asset is
absent. So in which case, okay.
Yes, Ivan.
So directions for filing of statement of affairs. If the petition is not filed by the company, the tribunal, what does it do? It will direct the company to file any objections if it has with relation to the petition filed, and statement of affairs within 30 days and extendable up to more 30 days. Then ask petitioner to deposit any security for cost. So any cost that will be incurred, the tribunal might also direct the petitioner, in case if it's not a company, to deposit those costs with the tribunal. If the company fails to respond, it will, of course, lose its right to oppose, and the responsible officers may face any penalty. After the winding up order, the directors must submit audited accounts within 30 days to the liquidator. Penalty is, if in case of non-compliance, will be 6 months of imprisonment or 25,000 to 5 lakh fines, or both. The complaint can be filed before any special court by the registrar, liquidator, or authorized person. Appointment and removal and replacement of the liquidator. Who can be a liquidator? The tribunal appoints them from the panel of IBBI at the time of the winding up order. The liquidator may be appointed with restricted powers or full powers initially if there's any provisional liquidator that's appointed. Terms and fees are generally decided by the tribunal depending on the size of the company, the task that the liquidator might have to undertake, experience, qualification. Also, if there are a lot of assets in the company, then the task is bigger, to sell them off. So the fees totally depends on that. Also, the once the appointment is done within 7 days, the liquidator, if there is any conflict of interest, if at all, there's a declaration that has to be filed with the tribunal within 7 days of the appointment by the liquidator. The provisional liquidator can be confirmed as a company liquidator for full winding up proceedings. Removal and replacement. The tribunal, in certain cases, may remove the liquidator. It could be on the basis that the liquidator has conducted some fraud, incompetence, conflict of interest, inability to act. It could then be on event of death, or if they resign themselves. If in case of all of that, the work will be transferred to another liquidator. The tribunal, in case there's any loss, that has occurred due to the negligence or fraud of the liquidator, the tribunal can recover these losses. Of course, a right to heard will be given to the liquidator before removal on these grounds. Next is rule. We'll deal with rule 100 to 125, which is debt and claims. How are the creditors going to file their claims in respect to the company when the company is undergoing winding up by the tribunal? One is notice to the creditors. It will be issued within 30 days of the winding up order. What happens is public announcement is supposed to be made in English. One is English language and one is the vernacular language in the place where the registered office of the company is. And if there are any known creditors, as per the statement of affairs available with the liquidator, they might send them such notices on the addresses that they available to them. Then is proof of debt. Once the public announcement is done, the creditors have to submit their proof of debt via an affidavit in the form 44. This form will also include account details, all the transactions that has happened, what kind of first creditor they are, all of those details. Workman claims, if there are a lot of workman claims, those have to be consolidated by one representative or one person belonging to the category together and then submitted to the liquidator. Then what happens after that? Once the claims are received by the liquidator will review all of those within 30 days. Acceptance and rejection, whatever happens, it has to be communicated duly to the creditor. Now, appeal, what happens if the creditors are dissatisfied? If the creditors are, if the claim has not been admitted to the extent they, had claimed, or a part has been admitted or it has been rejected, whatever is the grievance, they have to file an appeal to the tribunal within 21 days of the intimation received by them from the liquidator. Then the final list of creditors, the final list with as per the liquidator after admission, changes and everything that has to be filed with the tribunal. It can only be changed, or any changes thereon later can be made with the approval of the tribunal. Whoever misses to file the claim within the prescribed time as per the public announcement, they can of course seek for condonation from the tribunal and then file their claims. Next is intimation to company liquidator, provisional liquidator, and registrar. Now, within seven days of the order being passed, the tribunal must inform the company liquidator or the provisional liquidator and registrar the passing of such order. Then the registrar will update his records and intimate any stock exchanges if the company is listed. Now, on winding up order, a notice of discharge to the employees has to be given unless the business is continuing for whatever reasons. Then within 3 weeks, the liquidator will seek for constitution of winding up committee. Now, the winding up committee has to be will help the liquidator to take over assets, review affairs, recover dues. They will also help with audit reviews, asset sale, finalize creditors' contributory list, and to settle claims, pay dividend, and report monthly to the tribunal. They will include secured creditors nominee. If there are any secured creditors, a nominee of the secured creditors, a tribunal nominated professional. This could be anybody. This could be a chartered accountant or any person who can help the liquidator with the financial aspects of the company. Then is effect of winding up order.
This nominee of this
Secured creditor.
deal, the tribunal nominated professional. So tribunal nominate them, or we have to.
We have to give a name.
So RP has to give the name.
The liquidator will, after discussion with the creditors, they will nominate somebody among them to be their nominee, and that person's name we have to file with the NCLT and ask for
And your creditors nominee, but the second is tribunal nominated.
this one. In this case the tribunal appoints.
Appoints.
Considering on basis of the reports, if there are any assets or all of that, they will figure out if any professional is, if at all required. If there are no assets or nothing, they do not appoint any professional in that case.
So that means it's optional for the tribunal whether to decide to appoint a nominee or not to appoint the nominee.
Yeah.
Okay. So that means that will depend upon the circumstances of the company and the case. Yeah.
Yes, that's right. Then effect of winding up of order. Now, as if it was made by their joint petition. Now what happens to the suits pending to the litigation that was going on as on the passing of the winding up order? After the winding up order is passed and appointment of the liquidator is done, no new proceedings can be initiated. It's like a moratorium. No new proceedings. Pending litigations are allowed, but it is with the permission of the tribunal. The tribunal will decide such applications within 60 days, but this does not apply to higher courts, which is High Court and Supreme Court.
Which is not the case in IBC. In IBC, entire moratorium against everything except criminal. But in this case, pending before Supreme Court and High Court can proceed.
All smaller courts will be stayed.
And tribunal may also allow other cases if required.
Yeah.
Mr. Mehta, Mr. Mehta, even in terms of moratorium, if you see actually in IBC and again in practicality, even if there are certain cases where you still proceed and obviously the RP continues, but in some of the judicial precedents, they have also said that anything affecting the company's assets and as far as the claim is concerned, you may not be passing the order. So let's say if there is an arbitration ongoing and there is a passing of the award or there is an execution. However, there have been some instances where the courts have taken little view that they are continuing the proceedings to strictly a moratorium. Okay, I mean, as far as this is concerned, and it is quite vague because they say, okay, there is nothing which is passed, but strictly speaking, and it's a very vague order. I think if I remember, it was the Calcutta High Court, but I just thought I'll point it out. But it's completely contrary to the moratorium provision, as you rightly mentioned.
Yeah, thanks. Thanks for giving. Yeah.
Next is the jurisdiction of the tribunal. Now, the tribunal will have the exclusive jurisdiction over all matters relating to winding up. Tribunal in this case is, of course, the National Company Law Tribunal. It will have jurisdiction over suits or proceedings by or against the company, any claims, questions of law or fact related to the company assets, rights, obligations, and so on. This applies before and after passing of the winding up order. Before is on filing and after is till dissolution. Then is submission of report by the company liquidator. Now, the liquidator is supposed to, on appointment and within 60 days, the liquidator is supposed to file a report with the tribunal. Now, what this report must include is important aspects with relation to the company, which is the assets. Now, it will be with a valuation report by the registered valuer. Capital issued, subscribed, and paid up. Liabilities, whether there are any secured, unsecured debts due or guarantees, then contributories, all the IP assets, contracts, all the legal cases. If there is any group structure, holding company, subsidiary companies, or all other information that the tribunal might, ask for. Then the report must also include fraud, if there is any fraud, company formation and promotion. Business viability, if there is any steps that the liquidator proposes to take to maximize the asset value. This could include sale as going concern here. Then it would be may submit any other reports. The creditors and contributors can inspect these reports by paying the fees as directed under the rules. Now, Section 25 to 27 are the relevant rules for this section. Report has to be in Win 16, Form Win 16. Promoters, directors, and officers have to assist the liquidator. The tribunal, after receiving such report, will fix a date for hearing within 7 days. The liquidator will, of course, attend the tribunal review. It could be personally or via its representative. The tribunal may then, on receipt of the report, have a discussion, to ask for clarification or any other directions. It may pass any other directions.
So
This
when you're saying here business viability, that is, selling the assets as a going concern,
Yeah,
it appears that means it is one of the things where the business is actually getting revived. Alternative method,
Yeah.
what we talked about it.
yeah.
Yeah.
But it nowhere it's written, but it's just like you could
take
that
the shelter under that provision,
yeah.
apply for that direction.
Yeah, that is what. Because when we are talking about it, when you say business viability with the selling as a going concern, then automatically imply the business revival could be done under this. Yeah.
That exactly that suppose if the company has not filed and this petition has been filed by somebody else. So in that case, the RP, the liquidator appointed will go through this all the assets and liabilities and structure, whether it is working. See, the promoter director's officer has to help him. So they will explain him the circumstances, and with this he may form the opinion and give that why he is thinking that this business is viable, not to be taken to be closed, and how it may be under stress, and how it is planned to improve the working and maximize. So this report is very crucial, and that's why it has a many things to be covered, though the timeline is also very less. And on that basis, NCLT will take a call. Yeah.
Okay. Understood. Yeah. Go ahead, Shiva.
Now, what the directions that the tribunal may pass on receipt of the report by the company liquidator. The company, the tribunal then will, after understanding the assets, the complexities that the winding of the company involves, will fix a time limit. Unlike IBC, we have like a timeline. Here, the timeline is fixed by the tribunal itself. It could decide on basis of the report that has been submitted by the liquidator. Also, this time may be revised or time to time if the proceedings are no longer economical or beneficial. The tribunal can also order for sale of company as a going concern or asset wise, or formation of the sale committee, in which the sale committee will have the creditors, promoters, and officers if it thinks that is a viable option. If fraud is reported, if at all, in the report, it can order an investigation. It can pass orders for investigation of the fraud, further investigation, and or direct any criminal complaint. Tribunal may then also take steps to preserve, enhance the asset value. In this, the tribunal can also, direct to continue the business of the company, not particularly a new venture, but it can, direct the liquidator to carry on business if it is for the beneficial for winding up of the company, and of course with their approval. It can sell assets as going concern, avoid any losses on contracts that are already in progress, and to recover dues. The only objective behind this is for continuation of the business is not profit or future expansion. It must only aid the winding up process or protect stakeholders' interest. So that can be done under this section. Next is custody of company's properties. On winding up or provisional liquidator's appointment, the liquidator must take control of all the assets, effects, and claims.
Shivan, I'll just say, since the question was asked about defunct and told to ROC, company has not filed the return and all that. You see, the difference will be why defunct and not this. ROC may, if you observe, there are many cases where there was pending recovery. Ideal case for defunct will be no asset, no liability. And where there is a liability and charges, and the ROC strike off the company, then the creditors doesn't have say as such. Many times what happens that even the assets are there but not disclosed. In this kind of situation also it will be risky and it get revived and then the steps is taken. So depending on the situation, the registry will take a call whether this can be taken under defunct or we can go under this provision, so that in this actual assets you have to trust the assets, get it, recover, pay to the creditors and then close. And that's why they may prefer here. And not only that, the chances of revival and sell as a going concern is possible. So, keeping in mind the economical value of the organization, though the non-compliance, the legal process may start, but the closure can be in a different way. Accordingly, the registry will take a call instead of defunct. Since the question was going on. Yes, Siva.
Let me continue. All company properties deemed to be in the custody of the tribunal from the winding up order date. The tribunal can also direct the contributories, employees, bankers, agent to hand over money, property, or records to the liquidator. Then the promoters, directors, etc. have to cooperate with the company liquidator. The promoters, directors, officers, and all the employees in relation to the company must they are required to cooperate with the liquidator. Any non-cooperation without any valid reason will be punishable with up to 6 months imprisonment or 50,000 fine or both. If cooperation is denied, the liquidator can always approach the tribunal for further directions, or the tribunal can order such persons to assist the liquidator as directed. This is similar.
Shivani, when you say non-cooperation without a valid reason, the cooperation is in any case is to be given. Non-cooperation means, it is all, yeah, because
No, in
it's,
certain cases, sir, for example, if the promoters or the directors or the employees do not have the information available with them that the liquidator requires, that could be one of the reason where if they don't have it at all, so that there's how they cannot cooperate. They have been saying that they do not have the documents, but we need the documents as the liquidator. So in that situation, it could be without any without reason, with reason, I mean, non-cooperation with.
no, right. But the thing is, the non-cooperation, when you are saying, they would like to definitely cooperate, but unfortunately, they don't have the value with the things. So that is the reason. So, yeah, non-cooperation means intentionally, we don't want to cooperate, something like that. It sounds, I don't know.
But sir,
About
in case if the company has not filed for winding up, if at all, that's the situation, and it has been filed by the registrar or the or something like that. In that case, there could be reasons for the directors or the promoters to not cooperate with the proceedings or the liquidator.
So, Balakrishnan, this is more of pairing material to a section 19, of the IPC. Same situation. Because there also, and I think what Shivani is trying to put in a point is that even if there are situations where the company or the directors do not have, as you also mentioned, right? But what happens in this case? Then obviously, even in 19, we obviously cannot go to third parties and seek information. But then there could be a situations where certain CAs will be asked to at least cooperate and give them some documents so that the winding up can be successfully concluded.
Okay.
Yeah.
Yeah, go ahead.
Now, settlement of list of contributories and application of assets. Tribunal will settle the list of contributories after winding up order. It may dispense the settlement list if the calls or adjustments are not needed. The tribunal distinguishes between direct contributories and the persons who are the representatives or who are liable on behalf of others. Only past members within 1 year may be held liable. The liability is limited to in case of company limited by shares, unpaid share value. In case for a company limited by guarantee, it could be the guaranteed amount plus unpaid share value. To get more clarity on this, the rules talk about how this process goes through. So what happens is, first the liquidator will file the provisional list on the basis of the information available within 21 days of the winding up order. After that, the liquidator will give notice to the list of settlement of give notice of list of settlement to all the contributories. Any objections that they have to be, there will be an application filed with the provisional list with the tribunal. If any contributory has any objection, they must file their objection with the tribunal before 2 days of the hearing. Now the tribunal will hear the objections and then certify the final list. After that, the liquidator sends notice to the final list of the contributors within 7 days. For if any rectification applications are there, that could have to be filed within the next 15 days. Tribunal may add, if there are any additions to this list, this can be done by means of filing a supplemental list. There can only be changes in the list by means of a tribunal order. The liquidator cannot do it by themselves. The liquidator can apply for rectification if errors are found, again by filing an application with the tribunal. Last, the tribunal may order list of past members if necessary, and the same rules will apply.
So friends, basically this is a list of contributory. That is, in our case, in company shareholders. So while we are telling that company is unable to pay and then we have to call the contributory, that is our shareholder, this is the process to be followed. And of course, it is of past 1 year member only, they are held liable.
Dikshit, I want to ask one small clarification here. When we look at these rules, somewhere the rule says it is within 2 days, somewhere it says within 7 days. When it comes to practically, whether that all happens within 2 days or 7 days or something like that.
So, very important and a very valid question, Mr. Balakrishna. Now, see, even under, again, I am always giving a little equation with the IBC, and obviously which is written here. Now, in see, most of these cases, obviously the legislature always puts these timelines, right? Because you have to obviously adhere to. Having said that, by and large, there are some cases which go and adhere to some of these timelines, because eventually when these the reports have to be filed by the liquidator, they will obviously be questioned by the NCLT. Again, having said that, because of the practical situation, there are so many of the times that the winding up and this cannot be actually completed within those time frames. So practically, yes, there is some which does not mention about the exact days of 3 days or 4 days or 5 days. There has always been, but the NCLT tries to the best of its time whenever, especially when a report has to be filed by the liquidator for giving the updates. I think there they are little crucial about the timelines, because they expect that for whatever work, they may hear the matter after 5 years, no problem. But the liquidator has to do his duty in filing his periodical reports in the timelines mentioned. If he has a problem, he is facing non-cooperation, he may prefer an application for. But by and large, again, some NCLTs will look at it absolutely strictly. Let's say an Ahmedabad NCLT, or let's say some other NCLT will look at it very strictly, maybe a Delhi NCLT. Bombay NCLT, depending on the members. But by and large, they try to comply with the timelines. However, again, the thumb rule, I think, and just to make it more on a lighter note, it's always directory, not mandatory. And then they try to say that this is in the up because there are so many situations which arises. So I think it's a very case to case. I think this doesn't have a very standard answer. But yes, timelines do go for a little haywire when it actually comes in practicality.
Somebody has put a question. What are the parameters based on which the company decides whether it should actually petition under section 270 under voluntary liquidation or under IBC?
So I mentioned this earlier also. I think somebody else also had asked this question. So parameters are more to do with, let's say if it's a cash-rich and a very solvent company and there is no default which has taken place, 59 of the IBC would be the ideal situation. Even if there is a default, assuming under 59 and the directors have to make the certain disclosures. However, I think the most important, at least on a very personal front, what I feel that parameters should by and large also depend on how quickly you think that the petition can be disposed of. As I mentioned, for a petition for a winding up under 271, I am doing a matter which was filed in 2017, 2018. I got the order in 2024, only for liquidation. I have still not dissolved the company. It will take another 2 years. However, in 59 of IBC, because everything is so process driven and everything happens with the liquidator's consent, the resolution is passed, eventually it goes there. So I think it will always just depend on, so parameters wise, yes, if there is no default under 59, because 271 doesn't talk about your default or anything. So that's a major obviously difference. In any respective, you can go for 271. However, in 59, there has to be a no default to occur.
Somebody,
because then
somebody's,
yeah.
Okay, go ahead.
Yeah, sorry. No, I said the other ways to also look at it is that it's not necessarily always you're looking at a voluntary or a winding up. Let's say if there is a default, then sometimes if you really want that the company, and let's say it's an MSM, you would want the company back in some form or the other, provided it goes. Then a Section 10 is possibly preferable. So I think everything just depends on what the company is looking out and how exactly are you wanting, either you wanting the company quickly liquidated. Let's say there's only cash balance in the company, which can be quickly disposed of. If somebody comes to me, I will say 59 may be the best option because that can be quickly done. But somebody tells me, no, there are some assets that will take its own time, then I can possibly look at winding up, or I can look at Section 10 of IBC to say, okay, there may be somebody who wants to buy out this, or I maybe as an MSME, if I'm an MSME, I can buy out the company. Okay. So it will all just depend on what exactly is the company or their shareholders or directors looking at.
Somebody has
I
put up a
will
question.
add to that see, what if the company want to close, if you have financial viability to pay all creditors, voluntary winding up is the best option. The reason being, it's a quick and it is the cash, the return to the shareholders or is very fast. And the pot comes at the end after the money is being distributed. While in other cases, court is continuously coming. But financially viable, voluntary winding up is the perfect suit. Anytime.
I agree
I'm
with
doing
Mrs.
day
Mehta on
in,
that.
day out for more than 2-3 decades of winding up. If you are financially solvent and there is no dispute litigation, then this is the best move. But if you are financially sound, but there is a dispute litigation, then you have to don't take voluntary, it can't happen. But if again you are not financially sound, then take this move. Because here the preference will be there, the payment will be there, payment to the creditors. This is a simple thing you can think of.
I will just add on to what Mrs. Mehta also said. So let's say if it's also a situation in the 59, I have to take the resolution past. Because if I have a serious deadlock between the company, I will never be able to go under 59. So then I have no other option but then to go under 271. Just to add on to what Mrs. Mehta said.
Yeah, so I said there is no dispute.
Yeah.
I hear the dispute only at the shareholders and management.
Correct.
Yeah. So any other than that, voluntary winding up is the best option. When you are financially sound and not dispute. Yeah, Dick.
Somebody is coming back on the delayed matter. He says that while process and details are very clear, we read about the news liquidation actually getting delayed from the rich experience of the esteemed panelists. Can we have actually examples what normally leads to this sort of the delay in the proceedings?
Sorry, I missed the question. Sorry.
No, he says, while the process and details are very clear, we keep reading that the liquidations are getting delayed. From the rich experience of external panelists, can we have some examples of what normally leads to the delay of these proceedings?
I think the straight answer to that is somewhere I would put it again in practical experience. It is really non-cooperation from the ex-directors and management to some extent, non-keeping of books, and also somewhere I would also take it from the NCLT perspective, though we know that now there are more benches coming up and everything. So I always equate it to do it from the company's perspective because their people are not filing their returns on proper time, and then they just leave the company to die its own natural death. So which actually really increases the delays which are causing for whatever reasons. I'm not getting into that reason. And I think second, it's also to do with how the companies and how the NCLT actually takes up these matters, because we all are aware that NCLT gives more priority to your IBC resolutions, CIRPs as compared to the winding up. Again, a very practical example. I'm not saying that every NCLT does this. Don't quote me to say that this is an every NCLT. No. Yes, but there are few NCLTs, and because this is a directive given by the ministry. because they want the resolution. So winding up sometimes takes a very backseat. So I think that to answer that, these are the two main factors. Non-cooperation, I feel, and non-keeping of books are very crucial. And obviously, I would say a sub-factor to the non-cooperation is also on how complicated, the assets of the company. Let's say the asset is today, there is an asset which is belonging actually to the promoter, then it is licensed to the company, then there is a dispute inter se between the director and the company. So that all leads to these procedural delays.
Somebody is actually putting the question, what is the difference between the strike off under section 248, winding up and the liquidation?
So strike off is a company for only when the ROC says that it is a non-filing for your returns, your financial returns. Having said that, the implications of the strike off does not mean that the directors tomorrow will not be responsible for any of their acts. Whereas liquidation and finally dissolution somewhere makes the process from the director's point of view that the company has been validly discharged of their liabilities. So striking off is only that because of non-financial, but the directors and the liability still stands. However, even in liquidation, there could be situations where the director's liability also stands. So I think the fundamental difference is that the ROC just without any opportunity just know that there's no running of any business and you've not filed any returns. And whereas in from a liquidation, it's a proper court process which actually leads to dissolution.
I will add on here that strike off is the action taken by Ministry of Corporate Affairs, Registrar of Companies. And in that, yes, of course, two-way it happens that the company itself also approached the registry for strike off. And they insist that there should not be asset and liability and no pending dispute. So that the company records are removed from the MCA records. But please note that the company remains here. The records are moved, and that's why the company can be revived. So in many cases, there was a recovery in the company, charge was there. The ROC itself has strike off because there was no record filing non-compliance. Then it was revived in the record by MCA, ROC, and then the IBC proceedings started. Again, in the fund company, if your company itself goes, as Dikshat rightly mentioned, you have to file the affidavit that we are responsible over the years, 20 years. So directors are still responsible. As regards the winding up here, voluntary winding up, since there is a financially viable creditors, it's proper notice, public notice and statutory authority notice is given. It is a very safe closure that you have given all the intimations to the public and the authority, and then we close it. That when with and also the closure is through NCLT, the court is and judiciary is involved, and then also our IBC process. Obviously, when that closure is there, it's a long detailed process, and equally 271. Here, each process judiciary is involved, so it's a very you can say safe closure, as Dikshat mentioned, that the directors and the contributories are not that questioned, especially directors.
Mr. Mehta, one more point I will add on to strike off versus to answer the panel query. So basically, even in let's say if in a strike off, because the company, as you rightly mentioned, it doesn't go off the records. There have been some instances where the NCLT has admitted petitions under IBC for a strike off company also, which means it doesn't solve the purpose. Because if I go under liquidation, then I cannot then go back. I cannot reverse the gear and say that I go back to it once it's liquidated and dissolved. But whereas if it is strike off, as you rightly mentioned, this is another factor that you always have a chance that now strike off that a creditor can come and still say that no, a CRP should be initiated, which means you're not solving any purpose for the strike off.
Yes, you can go ahead. We'll discuss a lot.
Next, we'll be discussing the advisory committee. To sum up this slide, The tribunal may form an advisory committee, to assist the company liquidator or advise them. The company will consist of maximum of 12 members. The company liquidator will then convene a meeting of creditors and contributors within 30 days from the order of winding up, and then to determine the members of the committee. The committee has been empowered with the powers to inspect the books of accounts and other documents along with the assets and properties of the company under liquidation. This section provides that the committee will be chaired by the company liquidator, and the provisions related to convening of meetings or the procedure will be followed in the meetings, and conduct of the business of the committee will be prescribed accordingly. In this, vacancies are it will be filled by a fresh meeting. As I said, it will have minimum of 2 members. The committee can continue if there are minimum 2 members. Restrictions are no profit or asset purchased by members without the tribunal's approval. No special payments are allowed. It is only allowed with the order of the tribunal. Meetings can be called by the committee or 1/3 of its members. The quorum is 2 or 1/3 of total members. The members can resign or be removed.
Shivani, go slow, people. You can
Okay.
have time, no issue.
Okay.
Somebody is asking a question. If the company business is not happening for the last 2 years with no disputes, then also Section 59 voluntary winding up is possible?
Sorry, I missed that question.
Yeah, if the company business is not happening for the last 2 years with no dispute, then also Section 59 voluntary winding up is possible?
Yes, there is no restriction as that, no, because there is no default. And if, as I mentioned earlier also on the voluntary aspect, that one can obviously go in for that. And in that sense, if you also see, technically the company may also become inactive as per the ROC records. So, but you can always go ahead and say that, yes, there is nothing in this company. We had formed this company for an X purpose. And the purpose, because for whatever reason, we never got any license or anything. And we are now wanting to liquidate this company.
Somebody put up a question in the case of the winding up, how the employee will be compensated. In fact, I understand in any process, whatever you talk, either liquidation or winding up, etc., there is actually a priority payment of settling the employee's claim will come actually. It has to get settled, isn't it?
Yes, sir.
Yes, it will be. And one has to see the provisions of, I think, 326 and 327, if I recollect correctly. Those are those provisions which mention, because they were exactly 529A under the Erstwhile Companies Act 56, now which has been codified under the 2013, which talks about those preferential payments, because this is absolutely contrary to what is mentioned under 53 of IBC.
Somebody has put up a question. One company have got 2 brothers as shareholders and the directors with no creditors or liabilities. Can voluntarily winding up the directors plead that the land and building is transferred to them upon the winding up of the company without going for the sale, because that sale of the property will go to the outsiders?
No, again, this is very subjective, and this is also will depend on the valuation being conducted. So let's say, obviously, if there are certain other creditors which have to be paid, just because under the garb of taking the property back, you are adopting this mechanism. I think this is very subjective, and that to be answered in terms of the valuation of that particular asset. Otherwise, every company would just look at the same way, no? Look at a scenario where I will just say that let's do this so as to get the asset back. And no way we do that even in Section 10 when we go and file as an MSME and say I will take back the company not at 100 rupees but at 40 rupees. But then I have to match some kind of a valuation.
I think he's talking about voluntary liquidation. In voluntary liquidation, in distribution in species is possible, but based on again, as it is, the distribution will be based on your contribution, that is your shareholding. So as proportion, if the asset is 100 and your proportion of shareholding is 50-50 between A and B, then 50-50 will be only given to A and B. So your property valuation should be accordingly worked out. So we have done this kind of voluntary liquidation in specie distribution with some money and arrangement, and the Mumbai NCLT is allowed, but the valuation and all that to be taken care, and it can be distributed in specie instead of waiving out.
Yes, but that's exactly, Mr. Mehta, you just put it correctly. It's all will depend on that valuation.
Yeah,
It can be a case that I will deliberately go down the valuation so as to under the garb of taking the property back.
Correct. You put it very correctly there. That's right. A share has been actually sold off before the winding up process is commenced. Can the shareholder be actually called to make any contribution?
Well, that is, I think I mentioned yes on the chat box already. I think that is already because there are mechanisms under the this setup because they will have to contribute to the assets and the liabilities to the extent. Obviously, if the shares are interstate, transferable, and everything, yes, they will maybe called upon to say that you transferred it unless it's for valid consideration or for whatever other reasons. There are situations where, and in fact, in one of the cases, the shareholder was called upon to contribute to the assets of the company. To the best of my recollection, I think this was a 2019 or a 2020 case before NCLT Mumbai.
Kindly discuss on the voluntary liquidation between the holding and subsidiary company, wherein the subsidiary is a material subsidiary of a listed company.
Sorry, I didn't get that.
Kindly discuss voluntary liquidation between the holding and subsidiary company, wherein the subsidiary is the material subsidiary under the listed company.
So again, you will obviously here you will under the voluntary liquidation. Then because it's a subsidiary, it's a wholly owned subsidiary of a listed entity, there would be certain SEBI impediments and your listing regulations will also come into place, where you will have a situation where the company, because somewhere, I mean, we all do this in a company structure where the subsidiary is formed, and then you actually are moving everything from the holding to the subsidiary and trying to, under the garb of liquidation, you're trying to hive off certain assets. But if the intent and this, then the NCLT may just also come and say that 1 minute there is a situation where you are not possible to do this because it is really going to affect the listed entity. So this is again a very subjective question. It will only just depend on the fact.
Correct. Case to case basis. We cannot specifically answer, but unless we know the full thing that is there.
Yes.
Is there any time limitation as how long they can go back? I think it is in connection with the contribution, I think so.
So if it's for a fraudulent purpose, it is somewhere just to go beyond 6 months. And if you have transferred not in good faith, it could go up to 1 year.
Okay. Yeah, go ahead, Shiva.
Then is after the advisory committee is submission of periodical reports. This is similar to IBC or quarterly reports that are to be submitted with the tribunal. Just to give an update as to
people do not know completely here all participant about IBC, so go slow on that part. Okay.
Quarterly reports have to be submitted with the tribunal, giving all the details of the process of the winding up. So it starts from Jan to the quarters are Jan to March, similarly till December. 4 quarters, it has to be submitted. The tribunal will review and modify again its orders on basis of this, the reports that are submitted from time to time with the tribunal. Then is powers and duties of the company liquidator. Once a company liquidator is appointed, they have to take control of the company's affairs to ensure that the process of winding up is conducted smoothly. The primary role and key functions include it will be calling off the meeting of creditors and contributories to take decisions time to time, settling the list of creditors and contributories who gets paid in what order, then valuing of assets and liabilities to prepare for distribution. Then realizing assets and distributing the proceeds, investigating for any fraud or misconduct and reporting the same with the tribunal, also maintaining proper books of accounts and filing periodic reports to the tribunal. Of course, with the approval of the NCLT, the company liquidator can take help of professionals. It could include CA or CS lawyers to assist them in their duties. The appointed professional also has to file conflict of interest with the tribunal.
So friends, here the even appointment of professional you require a tribunal approval. So comparative to in IBC, this process involves lot of directions from NCLT, lot of filing of forms. That is the basic difference I observed as such. Yeah.
Then is exercise and control over company liquidator's powers. A liquidator will have to follow the directions that is coming from the creditors and contributories or the advisory committee. In case there is any conflict, the directions of the creditors or the contributories will prevail. The liquidator can or must summon meetings to know their opinions from time to time. 1/10 in value can request a meeting in writing. Any aggrieved persons with the liquidator's decision can appeal to the tribunal, and the tribunal may modify or reverse the liquidator's decisions. Now, conduct of meetings of the creditors and contributories. Rules 44 to 65 deals with the conduct in the manner in which these meetings have to be conducted. Notice, 14 days notice has to be given via post or by electronic means. If there are more than 500 creditors or contributories for that matter, it has to be an advertisement similar in one English newspaper and one regional language. The officers may also have to attend or submit written information. Notice formats are in Form Win 25 to 30. Meetings, can be held at a time, place convenient for the majority. It will be chaired by the liquidator. Quorum is 3 creditors or contributories or all. If not, then adjournment has to be taken. The resolutions are deemed to be passed by majority in value who are present personally or through proxy. Voting, only those with admitted proof of debt in case of creditors can be allowed to vote. Secured creditors vote only on balance after security valuation. Voting is deemed surrender of security unless it has been corrected. A liquidator can challenge a vote post meeting if he does not agree to the uh, whatever resolution has been passed. Chairman also decides on vote validity subject to the tribunal appeal. Records and reporting, minutes have to be recorded within 30 days. It has to be filed with the tribunal. The results of the meeting have to be filed with the tribunal within 7 days. All the cost in relation to these meetings have to be borne by the company. Next is Section 293, books to be kept by the company liquidator. The company liquidator will maintain all the prescribed books and record all the meetings and other required matters. The creditors or contributories can inspect these books only with the approval of the tribunal. Now, audit of the company liquidator's account. The company liquidator must maintain proper books of receipts and payments. It will submit all the audited accounts twice a year to the tribunal, half-yearly reports. Tribunal can inspect these books or ask for any other documents. Audited accounts, one copy will the liquidator has to give to the tribunal, one will be given to the registrar. And in case of government companies, all the relevant governments. Printed copies or summary will be sent to all the creditors and contributories unless this has been waived off by the tribunal. The relevant rules for this section are Rule 81 to 99, fund management and reporting. The liquidator must file quarterly reports with bank statements. The quarterly reports must include all the bank statements. A separate account has to be opened by the liquidator for the purpose of this process. All checks, securities, and payments will go into this special bank account. A separate dividend account is required for any payouts. If there are no assets, the liquidator may use government advance with tribunal's permission. Then is investment of surplus funds. Any idle funds can be invested in government securities or interest-bearing deposits. Due diligence is required for this purpose. Liquidator has to review monthly and record the decisions. All investments that are made and held through bank on liquidator's request, tax refunds must be reclaimed. Now, filing of an audit of accounts. Half-yearly filing of account has to be done, as I mentioned previously, with the tribunal, and also final account on closure. Form Win 39 to 42 must be verified by an affidavit. Then even if there are no transactions for the last quarter or the last half year, still no nil affidavit has to be filed with the tribunal. The accounts are then sent to the auditor by the registry appointed by the tribunal. Chartered accountants from tribunal panel will audit. Audit certificate is then filed with the tribunal ROC and shared with the liquidator. Audit fees are decided by the tribunal, which has to be paid from the company's assets. Inspection is allowed by any creditor or contributory with the following fees. Tribunal then considers account and audit report for final orders. So all the reports that are filed with the tribunal keeps considers all of those reports, ones that are filed by the liquidator, ones that are given by the auditors, to decide the final order for winding up of the company.
So just chartered accountant, please note that at NCLT you get empaneled as a chartered accountant, and this kind of job is the same.
Now, payments of debts by contributories to the extent of and set off. The tribunal can, in case the tribunal can order any contributory to pay money due to the company. Set off is allowed, but only in specific cases. For unlimited companies, set off permitted for independent dealings, but not on dividends. For limited companies, it is allowed for directors and managers with unlimited liability. If all creditors are paid, the contributories may set off dues. Then power of tribunal to make calls in this case. After winding up order, the tribunal can call to
Shivani, go slow. This set off is very well mentioned. That here the questions were there on set off. So here set off is allowed in specific cases for unlimited companies. Set off is permitted for independent dealing, so and not for dividends. Okay, and for limited companies, it is allowed for director and managers because they have unlimited liability. As you know, directors and managers. So if directors and managers has to receive anything from company, they can set off against their liability. In case of limited company, to no other set off is allowed. But in case of unlimited companies, the set off is permitted for independent transaction. Yeah. But if all creditors are paid, contributory may set off dues against future calls. In the sense, future calls, of course, the company is getting closed and the future calls liability, if you remember, under Companies Act remains. But since it is now all creditors are paid, the contributory will set off against their dues. Okay, yeah.
The power of tribunal to make these calls. After the winding up order, the tribunal can call contributories to pay amounts as needed to cover debts, liabilities, and winding up costs. It can also order payment of such calls to adjust rights among contributories. The tribunal shall adjust rights among contributories and any surplus to be distributed to the entitled persons. If company assets are insufficient, the tribunal may order winding up costs to be paid from assets in such priority order as it deems fair.
So friends, here even the preference is directed by the court. Yeah.
Power to summon persons suspected of having property of the company. During the winding up process, if the tribunal has wide supervisory and investigative powers to ensure that the process is fair, transparent, and free from misconduct. These powers help in detecting fraud, holding delinquent officers accountable, and protecting creditors and shareholders' interests. So the tribunal can summon officers or others with company's properties, book, or information. It can examine them under oath and require production of documents. The tribunal may also order payments of debts owed to the company or order delivery of company property which has been held by others. Lien claims on documents allowed.
Shivani, just sorry to interrupt you. This order, because I'm sure that there will be some question that how it is executable. So under the same provisions, there is also a mechanism that this order will be treated like a decree for the payment of a delivery of property, just like under our CPC. Go ahead. Sorry.
Non-appearance of these officers may lead to cost penalties. As Sir said, orders are enforceable like civil court decrees, and a payment or delivery as per the order will grant legal discharge. Power to order examination of promoters, directors, etc. If any fraud is reported by the liquidator in any of its reports, the tribunal can summon and examine the person concerned. Again, examination on oath before the tribunal or authorized person. The company liquidator will of course participate with legal aid if authorized. A person examined may get a copy of the report at their own cost or hire professionals to assist them during the examination. The person can apply to clear their name. Tribunal may award costs if exonerated in case they're not found guilty. Examination notes are recorded, signed, and can be used as evidence further. Creditors and contributories can inspect these records. Arrest of persons who are trying to leave India or abscond. Tribunal may detain a person, a contributory or holder of company assets if they're found trying to leave India, abscond or hide property to evade dues or avoid any examination. The tribunal also has the power to seize books, papers, and movable property until any other further orders. Now we can discuss sale of assets under the company winding up rules. Rule 165 talks about sale to be subject to sanction and confirmation. The liquidator must take prior sanction of the tribunal before selling any property of the company. All these sales are subject to confirmation by the tribunal. The requirement is the tribunal's oversight is mandatory before and after sale unless tribunal waives it themselves. The practical implication to this will be it prevents undervalued or unauthorized sale of assets and ensures transparency and fairness to the creditors. Next is Rule 166. Procedure at sale. In what manner will the sale be conducted? The sale will be conducted by the liquidator, by an approved agent or auctioneer. Tribunal decides the method of sale. It could be either public auction, seal tender, e-bidding, or so on. Requirement is the method of sale must and compulsorily be approved by the tribunal. Its practical implication is that this enables a fair and competitive process. Tribunal can choose best method depending on the nature of the assets. Then Rule 167 is the expenses of the sale that has been conducted. Gross proceeds of sale must first go to the liquidator. Expenses, fees of auctioneer or agent are paid afterwards as per tribunal approved sale. A liquidator receives total proceeds. Agents are paid later under tribunal guidelines. This ensures that all sale proceeds are accounted for and expenses are properly documented and authorized.
Dikshat, just what we can observe is that if we have IBC and this the section 271, the section 719 and this, what is the major difference is observed is under IBC, the committee of creditors has lot many powers and even the liquidator has powers. While in this case, it is basically that liquidator has to go for each and everything for direction to the court. And the power of committee is very, very limited. Further, in case of, the question was, what is the difference if you say that in this section 270, it straight start with the liquidation. The person is appointed as a liquidator, though in IBC it is first the resolution plan and the possibility of withdrawal and also the other possibility to revive. Before the liquidation order pass, here straightway process start with the liquidation. Though here also revival possibility, the court do not give order straight. As we rightly mentioned earlier, that report is very crucial. If the liquidator feel that there is a chance of revival and he report, then court may accordingly direct, and he has to seek the direction. The court may direct. So it is through court process. This is the difference. Here the committee of creditors and there is a process how if the company will be revived. And here it is straightway liquidation, but before liquidation, the both liquidator has to report and the court can give direction. This is the difference. And of course, voluntary liquidation and strike off we explained. So you can say the basic mota difference is this. Dikshat, if you want to add something.
Yes, no, you're absolutely right, Ms. Mehta, that the actual thing is that to go to court and the liquidator at every given point of time, and just to put it more in perspective, let's see, there are certain decisions under IBC which are taken at the level of the COC. So he may not want to always go back to the court, right? It is just like an arbitration. I equated something with an arbitration proceedings. So you're absolutely right. The major difference is that to going back to court for small things, whereas in voluntary liquidation also, I do not have to go in court except doing filing those applications and getting eventually the company dissolved. But under this 271, there are a lot of situations where the liquidator has to come back, because you have to also understand the basis on where this is coming in. This is coming under the Erstwhile Companies Act, under 56 also. If you realize, every time the official liquidator had to go back to the High Court and take certain permissions. So having said that, you're right. This is more to do with getting the interference by the NCLT, whereas in the other provisions, only when a resolution plan is ready or the company plan approved or it goes for liquidation. So you're right.
And of course, you mentioned that earlier that default of 1 crore for IBC.
Obviously, yes, I did mention that.
Somebody is actually raising the same thing related to that.
Yeah, I answered that. Yeah, the same, right?
Yeah.
Yes, Ivan.
So once the assets have been sold off, the list of contributors has been settled, the creditors or the claims have been admitted, and all of the process has gone through. The payments can be made, to the contributories or creditors, the liquidation cost. Particularly, Companies Act has not given us like a waterfall mechanism that is the IBC gives us, Section 53 IBC gives us, like in which manner or which priority the expenses, the creditors or have to be paid. So here, if we go to see, we can take a reference from Section 326, 27 and the IBC. So first, of course, the liquidation expenses will be paid, which have to be approved by the tribunal first, all the liquidation expenses. Then will be a workman dues and secure creditors, which are in pari passu with each other. Section 326 talks about it. Then will be the government dues and any other preferential creditors. Then comes the unsecured creditors. And if at all anything remains after paying off all of all of these parties, then the contributories will be paid.
Richard, you would like to comment on this?
Yeah, just a small comment that there is some reference given under the Companies Act and what the liquidator has to follow. As rightly mentioned by Shivani, there is a reference mentioned, and 326 and 327 is what they have to actually follow. But this is in direct contrast to what we have under IBC 53, because there it is the liquidation cost. Then you have your secured creditors. And as far as the government dues are concerned, if you see the difference, major difference, you see that the government dues there under IBC come absolutely last, whereas in Companies Act, we are taking them up. So that becomes a major
difference.
Yeah.
Yes.
So after all the payments have been made, all the parties have been paid, then the final steps there will be final steps in winding up. The key actions would include disposal of books and records of the company and liquidator as per the tribunal's directions, preparation of final accounts by the liquidator showing how the assets were realized and how they were distributed, submission of final report. Now, this final report will include the entire process, the manner in which the process was conducted, all the details with relation to winding up, and then will be the dissolution of the company by the tribunal's order once it is satisfied with the reports and the filings done by the liquidator. Here again, so once the winding up is complete, liquidator will apply to the tribunal for dissolution. Tribunal may order dissolution if it finds it just and reasonable. Within 30 days of passing of this order, the tribunal and liquidator will send this copy to the registrar, and the registrar will record company dissolution in the register. Now we can discuss the role of tribunal per se in winding up. Now the tribunal initiates and oversees the entire winding up process under the Companies Act 2013. It starts from passing of the winding up order to supervising the appointment of the company liquidator, settling the claims, finally dissolving the company. The tribunal ensures legal compliance and procedural fairness. It also sees to it that it safeguards the creditors, interest of the creditors, contributories, and employees. This is transparent asset realization and distribution, resolution of disputes and fraud investigations, timely closure through structured reporting and audit reviews. By exercising judicial oversight, and enabling professional support, the tribunal facilitates an orderly and just liquidation of the company's affairs. Next, we can discuss the challenges that are faced by the tribunal in winding up matters. First will be the procedural delays. Now, there are multiple procedural steps, which is included under winding up, which is admitting the petition, issuing notices, appointing liquidators, reviewing reports. This can take some significant time. Frequent adjournments, lack of timely submissions by the parties that are involved, and some disputes again slow down the process. And also, not to forget, the growing backlog of cases with NCLT also reduces the tribunal's capacity to handle winding up cases, as Sir mentioned previously. Then would be asset valuation difficulties. Accurate and fair valuation of assets is one of the crucial for proper distribution, but is often delayed due to lack of registered valuers or available valuers. Disputes commonly arise over fair market value versus book value, especially in cases involving real estate, IPR, or any intangible assets. Prolonged litigation can lead to depreciation and degradation of perishable or idle assets, diminishing their final value. Then would be conflict among stakeholders. Creditors and contributories may have conflicting claims over available assets and liquidation proceeds. Secured versus unsecured creditors often challenge priority rights and entitlement to distributions. Allegations of fraud, mismanagement, or misconduct by former directors or promoters also can complicate the adjudication. Next is risk and safeguarding of company assets. There is always a risk of asset diversion, concealment, or unauthorized disposal, especially before the liquidator takes control. The tribunal has limited real-time enforcement power, relying on third parties. Example, it could be the police or liquidator to secure these assets. It is challenging to maintain physical and legal custody of scattered or foreign located assets. Last is limited resources and expertise. Shortage of skilled company liquidators who actually understand the process of winding up under Companies Act, forensic auditors, and this could kind of hamper the process. Tribunal often relies on external experts for specialized tasks, causing coordination delays and dependence. A lack of centralized databases, digital tools, and support infrastructure limits the tribunal's efficiency in complex cases. Ma'am, would you like to add anything to this?
I think you have elaborated lot of delays and everything. And as we are telling that NCLT's continuous intervention is required in this process, that is a major challenge.
Dikshat has given actually an example of a 5-6 years of winding up case, which he has actually cited in a private company, what he has mentioned in between. So it is definitely there. One of the challenges, mainly the delay. And again, the conflicts of various stakeholders' interest that causes. And many times what happens between the two groups, non-cooperation, which is the deadlock, that actually causes the problem. Those are all the things are practically seen it here. And one more thing is I would like to only add here, all said and done, okay, the liquidator has got a lot of duty in all said and done. The company is actually like a going concern till it is actually wound up. So what happens is the liquidator has taken responsibility not only towards the NCLT, but also in respect of the complying with the various requirements which are required under the Companies Act, such as, filing the annual return, filing the annual financial statements, the other things, all those things which is also required to be done. Otherwise, I have seen ROC has been taken left and right the cases against the liquidators and penalizing them for not compliances of the company under the IBC or under the liquidation period. That is also there. There is another challenge which is there with the liquidator also. Yeah.
Yeah.
Last, we will discuss some case laws in relation to winding up. The first one is Rajesh Agrawal versus Premier Proteins Limited. This order is passed by NCLAT New Delhi in March 2023. In this case, the NCLAT has affirmed decision of NCLT and held that subsection 2 of section 273 clearly indicates that if such petition is filed, that is petition filed under section 271E read with section 272(1)B of the new act, onus is on the applicant to satisfy that there is just an equitable ground for winding up of the company, meaning thereby that if any applicant is not in a position to satisfy on the point of just an equitable ground, the tribunal may refuse to make an order for winding up. Dikshit sir, do you have any comments on this? On just and equitable grounds?
Yeah, so just and equitable, as we mentioned, and I think Mr. Balakrishnan already at the start of the session, he had mentioned about, the just and equitable grounds, the serious deadlock, loss of substantive, the main objects for which the company was formed, that has not been able to capture. So that is an absolute ground for the companies to actually. And when I say serious deadlock, I think it is also to do with when a company files for operational mismanagement. There also the tribunal has power to wind up the company on a just and equitable ground. So I think this captures a lot of on what basis, and then obviously the onus will lie on why it is that this is just an equitable ground, because this is the only ground then available under 271. Because as I said, inability to debts has already been transferred to the IBC. So yeah.
The next case that we'll be discussing is Avirth Inc. USA versus Avirth India Private Limited and others. This order has been passed by NCLT Mumbai bench in August 2023. In this case, the petitioner, who was a shareholder, has sought winding up of the company on just and reasonable grounds, and the NCLT has admitted this petition. The very purpose for which the company was incorporated, the petitioner submitted that the very purpose for which the company was incorporated has ceased to exist, and therefore the very substratum of the company no longer exists. The business model of the company is not viable to continue considering the high expenses and less income. The trust and confidence between the petitioner and the company and its directors is lost. There is also no prospect of the company ever doing the business now that the relationship between these people are now irreconcilable. There are irreconcilable differences. Directors are deliberately trying to defraud the public, and from the correspondence, it seems that they are seeking to involve outside investors and defraud. Companies in the nature of a quasi-partnership, which does not want to, and they do not want to continue to the wrongful actions of the directors, it is just an equitable to wind up the company.
1 minute, Shivani, go there to earlier slide. Friends, as Mr. Dikshit mentioned that, deadlock and all that, similar situation that fraud, exactly the circumstances where you can read this, that the purpose is not served, business is not viable, and the directors are entering into wrong actions. And as I mentioned that when just and equitable, the courts feel that this is not viable, they are increasing the debt and the liability of other stakeholder, the court will give the direction that companies should be closed. So to avoid further dispute difference, this is the ideal case. You can study this, and it involves many things, questions to many answers.
Yeah, correct. This actually gives the reason why we put up this case is just to give all the grounds on which basis the applicant can seek for winding up on just and equitable.
Yes.
Somebody put up a question here, under the what circumstances the creditors who's not
I've answered that.
Okay, you already answered. Okay. Yeah. Okay.
The last case is Devas Multimedia Private Limited versus Antrix Corporation Limited. This is the Supreme Court judgment passed in January 2022. Devas, a company in liquidation, contested the winding up order issued by NCLT, which was upheld by NCLAT and subsequently appealed to the Supreme Court. The winding up was initiated by Antrix Corporation Limited under Section 271C of the Companies Act on the grounds of fraudulent activities, information of conduct of Devas affairs. The key findings of the tribunal and the appellate tribunal included: Devas was incorporated with the fraudulent intent to secure a significant contract without possessing the necessary technology or infrastructure. The agreement between Devas and Antrix was entered in through collusion and lacked a transparent bidding process. Devas conducted its affairs in a manner that violated the satellite communication SATCOM policy involving manipulation of official records and siphoning of funds for unrelated purposes. The shareholders and directors of Devas were implicated in fraudulent activities, leading to criminal prosecutions under various sections of the IPC and the Prevention of Corruption Act. The Supreme Court upheld the order of winding up, dismissing the appeals by Devas and DMPL, thereby reinforcing the provisions of Section 271C concerning fraud.
This was also quite famous when this was given Antrix and Devas.
Yes, this was one of the most important cases because it fell under 271C, and it had one of the few cases where the winding up happened under these provisions.
It was very much famous in media and all that.
Yes, yes.
So this gets us to the end of our slide, my presentation also. The conclusion for the entire process, summarize it in very short. So the winding up by tribunal ensures structured, judicially monitored closure of companies. It emphasizes protection of stakeholders, creditors, contributories, and employees. The company liquidator, of course, plays a central role in asset management, reporting, and compliance. The tribunal's oversight always maintains transparency, fairness, and accountability at each stage of the process. Provisions ensure proper asset realization, debt settlement, and final dissolution. The process balances creditors' recovery with legal safeguards for all involved. Yeah, that's it.
Thanks, Ivani. It was wonderful presentation. It was vast with lot of details, but quite well you have presented.
Thank you, ma'am.
And Dakshat, you were also very much involved. And friends, I must say, he is not on video because he's with some situation outside for personal reason. And with that also, he's attending this webinar. For that, he has come. He really deserve a lot because with a lot of difficulty, he's attending this webinar. Thanks a lot, Dakshat, for that.
Thank you, Ms. Mehta.
Yeah.
Sorry for the trouble.
No. Friends, Madhu, you can speak. We will allow you to. Now, the people who want to speak and ask the question, we will allow you. So, please, you can speak. You can unmute and speak.
Again, Jane is there. Was raise the hand.
Madhu, you can unmute and speak.
Yeah, any one of you can unmute and speak.
Now you can, as usual.
Yeah.
Whosoever-
Manish, Girija, Muskan, Hari, anyone?
Yeah, can you throw some light on Mr. Rajesh Agrawal case? Because just and equitable, is it staying away, being silent, or things which are not in your control or out of control, where viability is there, assets are there, no liabilities is there? Is it just and equitable?
Yeah.
Sorry, I didn't get your question.
We didn't get. Can you go slow little, Mr. Hari, please?
Yeah, see, just and equitable, the decision or the arguments held in the case of Mr. Rajesh Agrawal.
Shivani, open that slide now. Yeah. Yeah, please go ahead.
Rajesh Agrawal case, the decision was just and equitable for denying a winding up or a liquidator. So staying away,
Yeah.
no liabilities, or non-participation or cooperation, or alternate remedies available, or viability is there in the view of the liquidator or tribunal, are the basis for just and equitable.
It is. Dakshat, you will attend? Dakshat?
No, sorry. If I'm getting the thing correctly, I think it was breaking in between. I meant to say that because if it's a revival company and there is no viability option, are you suggesting then if there is no viability option, one can go for winding up? If I've got your question correctly.
No, sir, just and equitable. The very premise of the basis on which the tribunal or the liquidator reports matter.
Right.
How to assess? Is it the non-cooperation or the unwillingness?
Oh, no. So to assess is the situation, is the subsequent case law which was shown. If Shivani can do that, that is a subsequent. These are the grounds where the applicant will have to show these grounds only so as to make out a case for just and equitable. So it's a very ground specific on just and equitable what the courts, because if you see the act is silent on what are the grounds for just and equitable. It is only through these years where one comes across for just and equitable and gets out these grounds. So if these grounds, any one of these grounds are being shown by the applicant who comes before NCLT, and in this situation, the NCLT will then order winding up.
Thank you, sir.
Thank you. Thank you, Mr. Yeah. Anyone else?
Ma'am, my name is Girija.
Yeah.
Hello.
Please go ahead.
Yeah. Yeah, good afternoon, ma'am. My question is regarding this on the voluntary liquidation in case of the holding and material subsidiary company. Now, what is happening in case of material subsidiary company? It has no business since it is incorporation, and that's the reason since there is a 75% investment is there of the holding company. The holding company would like to go ahead and take a shareholders approval for winding up. So after that, it takes a shareholders approval. Then the subsidiary company is going ahead for voluntary winding up. So still there will be an issue.
Even you can close down the presentation.
So it is voluntary winding up process. If you follow, there is no issue. Why it is? I am not getting why you are asking this question.
No. The main reason is that in this case, it's a holding subsidiary fine, but the subsidiary company is a material subsidiary of this listed company. And that's the reason the holding company will go ahead and take as the shareholders approval in the general meeting, so that material subsidiary can go for voluntary winding up as per the sections. Okay, it's also going to appoint this official liquidator.
Yeah. So basically, holding company itself first take decision, and it also will pass the resolution.
Correct.
And then they can take it.
That can do. And there is one situation, ma'am, where the holding company has taken unsecured loan from its subsidiary company. So is it possible of any set-off, or is it holding company has to pay back the subsidiary company?
This requires study.
Yeah, that's correct.
Yeah.
Because it is 75% is the amount is coming from the listed company. So
it's a very specific, Girija. This required study and understanding, because that's why winding up liquidation, your balance sheet study is very much necessary.
Yes.
Often we cannot answer this question.
Yeah,
Okay,
this question
ma'am,
being a
thank you.
specific, this question
Yeah,
being a
understood.
specific question,
Yeah.
unless we know the full detail, it is not possible to give a right answer. So we call for the study. So she will not be able to answer this question. Yeah.
Okay, ma'am. Thank you.
Yeah. Manish or Muskan, you can unmute and talk. Manish, are you there?
Muskan?
I don't think they are there actually.
By mistake they have done or what?
Manish, are you there? Are you able to unmute and talk? I think maybe my mistake.
Yeah, I think if nobody is there with the question, we can close this session.
Yeah, of course we can close, and I would like to definitely give a appreciation to Shivani. She captured all the section very nicely. She puts up very good point by point, and she elucidately explained the things very nicely. Thanks, Shivani, for your good homework and also decided case laws what you have brought out. And of course, coming to Dikshat, first of all, I must be very much thankful on behalf of myself and also on behalf of Mehta and Mata. In spite of situations which is beyond things, you are able to participate. That shows your dedication for the profession, for which I am very, very thankful. Second thing, you add a lot of value with your practical experiences, and you shared the things with what is there, what is the practicality, etc. Many thanks to you, Mr. Dikshat. Thanks a lot.
Thank you. Thank you so much.
Thank you, Dikshat. Thanks.
Thank you, everyone. Thanks.
With this, we come to the end of the session. We close the session now. Next week, we will meet another session. Thank you. Have a very good day.
Thank you.